Hello and welcome to everyone joining us for this X Talks webinar. Today's talk is entitled Clinical Outcome Assessments and Copyright, Bridging the Gap Between Practice and Copyright Law. Where are we today? My name is Corey Stanton and I'll be your X Talks host for this event. At this point, I'd like to thank Mappy Research Trust who developed the content for this presentation. Mappy Research Trust is a nonprofit organization dedicated to helping the entire scientific community build patient-centric endpoint strategies and to facilitate access to clinical outcome assessments, commonly abbreviated as COAs or COAs. With more than 30 years of experience in the field of COAs and with the online platform eProvide, which provides access to all its COA services, along with databases on COAs, COA label claims with Pro Labels, and guidance with Pro Insight, Mappy Research Trust is the preeminent source of information on COAs. Exclusive distributor of over 800 COAs, Mappy Research Trust is the most trusted name in the distribution of COA instruments. One of our speakers today is Caroline Onfray. Caroline has been working in the field of COAs with the Mappy Group for 30 years, developing expertise in COA management, information, linguistic validation, and eCOAs. As the director of the author collaborations at Mappy Research Trust, her team is responsible for developing relationships and strategic partnerships with developers and owners of COAs to manage, license, and distribute their COAs worldwide. As the co-chair of the ISOCOL TCA SIG, member of the eCOA Consortium and ISPOR, and executive member of the Mappy Research Trust, she actively contributes to the development of innovative processes and solutions to support the COA field evolution for the ultimate benefit of the patients. And joining Caroline today is Cécile Wanon. Cécile is a French qualified lawyer. She studied private law at the Assas University in Paris, and after completing her master's in intellectual property, she did an LLM in Sydney, Australia, studying common law, international intellectual property, and business law. After working in Parisian law firms, she then worked for 8 years as corporate counsel for companies in the audiovisual and pharmaceutical industries. Cécile has been supporting Mappy Research Trust as legal counsel for 7 years and has developed her expertise on IP applied to COAs. Now, without any further ado, I'd like to hand the mic over to our speakers. Caroline, sending you screen control now, and you may begin when ready.
Hi, everybody. Thank you very much for registering to our webinar today. Cécile and I are delighted to have the chance to share experience with you about copyright and COAs. So, to administer a clinical outcome assessment in a clinical trial, whether it is the original version, a translation, or in an electronic format, sponsors should evaluate whether they need to obtain permission to use it and how to get access to reliable information about it. Permission to use is linked to copyright. The objective of this session is to provide guidance to tackle the challenges of identifying copyright ownership for COAs. And for this purpose, we'll let you know more about the fundamentals of copyright and their application to the COA field. We will present the process to mitigate risks of copyright infringement. We'll describe the various stakeholders involved in the copyright ownership of COAs, and finally, what responsibilities to expect from these stakeholders in order to make sure your use of COAs in your project is secured. In order to avoid any kind of misunderstanding, we just wanted to specify that the purpose of this presentation is to introduce the results of our work and to share the fruits of our 25-year experience in this domain. It contains the interpretation of the information that we gathered, but it does not pretend in any way to constitute legal advice. The advice of lawyers specialized in intellectual property are always, as you will see it, highly recommended. Before we go to the presentation, we'd like to hear more about your own experience, and we'd like you to respond to 2 questions. So, Corey, over to you.
Yes, that's right. Thank you, Caroline. We do have 2 interactive poll questions for audience members to respond to in real time to kick off our presentation here today. Appearing on your screen now, you can vote on the first question by clicking any of the answers and hitting the submit button. So the first question we have for you is, have you ever used a COA without seeking permission? And your options here are simply yes or no. And I'll leave the poll open for a little bit longer to allow our audience members to vote. Once again, that question is, have you ever used a COA without seeking permission? And we're simply looking for a yes or a no. And it does look like most of our audience members have voted now, so I'm going to go ahead and close the poll. And let's take a quick look at the results before moving on to our second question here. So again, in answering, have you ever used a COA without seeking permission? Overwhelming majority, 85%, have said no, while we have 15% at yes. Now, let's go ahead into our second poll question to kick off the presentation. The new question appearing on your screen is, have you ever experienced challenges to identify copyright ownership for a COA? And once again, we're simply looking for a yes or no response. So that's, have you ever experienced challenges when it comes specifically to identifying the copyright ownership for a COA? And I'll leave the poll open just for a few more moments to allow the majority of our audience members to get their votes in. And it does look like we've got most of you voting, so I'm going to go ahead and close the poll now, and let's share the results. So this time around, we see the overwhelming majority, 84%, have chosen yes in response to experiencing challenges to identify copyright ownership for a COA, with the minority 16% at no. Caroline, Cecile, I'm going to hand things back to you.
Thank you. Cecile, over to you.
Thank you, Caroline. So first, I'd like to congratulate all of you for answering that you have always, most of you have always seek permission to use a COA. It means that we have an audience who's familiar with the industry and knows that permission is required to use COAs. And to the second question, where the majority of you responded that yes, they encountered the challenges to identify the rightful copyright holder of a COA. This is specifically one of the topics that we will be talking about today. So yes, indeed, we as in the MAPI Research Trust and as any other actor in this industry have realized that it can be a real challenge to identify a copyright holder. And it is crucial that we make sure we don't use a COA without a proper permission. So let's see how now by having a quick look at the basics of copyright. So what is copyright? Literally, copyright means the right to copy. So this is the right to make copies, to modify, to publish, to perform, to publicly display, or to use in any way a work. And this comprises clinical outcome assessments. Nearly all countries in the world have laws protecting copyright. Most of the developed countries have adhered to the Berne Convention, which is the reference in intellectual property. So how is copyright created? Copyright is created de facto. It means that the protection exists as soon as the work is born automatically, as long as the work is created in fixed form. So it means that you cannot claim copyright on an idea because an idea has not been created in fixed form, but as soon as the work is in fixed form, meaning put in paper, for example, or a painting or a movie, it is the copyright is born at the same time that this fixed form exists. And the copyright immediately becomes the property of the author who created the work, the creator. So in theory, no action is required to secure the copyright. You don't need to register the copyright. It exists even without an official registration. However, if you register the copyright, it establishes a public record of the claim. It allows to date the creation of the work, which can be really, really important in case of any dispute around the interiority of the copyright. And also a copyright registration will be required to pursue any claim in court. And it entitles the owner to enhanced damages and attorney's fees if they are registered prior to the commencement of the infringement. So for evidence or proof, it is preferable to register your copyright. And similarly, the copyright notice, the little C, it's not mandatory. The copyright will exist even if you don't have the little C next to the work. However, again, it is really recommended from a legal perspective and even for all perspectives, because it allows you to inform others about the existence of the copyright, and also, most importantly, it facilitates the identification of the owner, and also is used to dissuade the public from using the work without permission. So the next slide is a more specific definition of the copyright holder's rights. So as I just mentioned earlier, the Berne Convention for the Protection of Literary and Artistic Works was concluded in 1886. So it's very old. It is the oldest of international copyright treaties, and it is the basics of all IP, intellectual property law, that you will find in most countries. It provides a high level of protection and gives authors the most comprehensive set of rights it is possible to give them. So it's a convention that most countries have ratified, and then so it gives basic rights, and then the countries will implement their own version and translate the Berne Convention into their local laws. So what about the rights of the copyright holder per the Berne Convention? The rights are divided in two. You have first you have the moral rights, which are personal and attached to the personality of the creator, rather than monetary and economic rights. So quickly, the moral rights, they are perpetual rights attached to the author. So they have no end. They will live forever, and they consist in the right to paternity. So it is the right of the author to claim authorship of the work, the right to be always identified as the author of the work. No matter what happens, the author always has the right to be identified as the author. And the other right is the right to integrity. So it is the right of an author to prevent distortion of the work, to preserve its integrity and reputation. And then you have the economic rights. Those rights are limited in time. They consist in the right to translation, the right to translate or authorize the translation of a work, the reproduction rights, it is the right to reproduce or authorize the reproduction of the work, the public performance, it is the right to perform the copyrighted work in public, and the adaptation or modification right, which is the right to produce an adaptation, to adapt the work based on the original work. So now, why is it important to identify the copyright holder of a COA and seek permission? What would be the potential risks and consequences of copyright infringement, of not identifying properly the copyright holder or not seeking permission? So copyright infringement is a serious offense. It is the use or the reproduction of copyright protected materials without permission of the copyright holder, in violation of international and national laws and regulations. So it can have really serious repercussions, especially in our field, in the clinical research field. First, it can lead to a legal action, which can cause you to pay monetary damages, payment of the copyright owner's attorney's fees, reputational damage, but also this could cause some delay in the studies, in your studies, because if you might need to use a different COA if you didn't require the proper permission. You might need to amend the protocol. We know that this can lead to a lot of consequences in terms of regulatory enterprise, and ultimately it may jeopardize or invalid some study results. So that's why the stakes are really high here, and also the fact that you are in good faith, the fact that you didn't know that copyright applied, it is unfortunately not a defense to infringement. So those wanting to use a COA are well advised to become knowledgeable on the basics of copyright protection as they apply to COAs, and to rely on the experts who understand the subject and can ensure compliance with all applicable laws and good practices.
Well, thank you, Cécile. So we've seen that copyright is born as soon as the work is created. So it's easy and straightforward. However, in reality, there are various moments during the questionnaire life cycle where copyright remains unclear or can be an issue. And this can start right at the time of the questionnaire development, but also at the time of the communication and publication about the questionnaire. And last but not least, at the time of the development of derivative works, for example, translations or modified version or equa versions. So at the end of the day, it might not be such a straightforward process. So let's have a closer look at these different situations and illustrate this with concrete example.
Thank you, Caroline. So yes, we will see that the copyright ownership can change throughout the life of the questionnaire. So what was right at the beginning or in theory may change during the course of the evolution of the COA. So just taking the time of the development of the COA, we have two cases here where the copyright ownership can change. The first case is the case of a COA that is developed while its creator is employed. So it can be the creator can be employed by a private company, by a university, a hospital. But you must know that in most countries, the copyright of a COA is created when the copyright the COA is created while the creator was employed. The copyright, the intellectual property on everything that this person will be producing during its employment, so not only the COA but everything that they may produce, will belong to the employer. So the entity, the legal entity employing the creator, becomes the copyright holder. So it would be the same, for example, of a COA that would be developed by academic researchers while they are employed by a university. In the US and the UK, by default, the employment contracts they automatically transfer the IP of a work created while employed to the employer. It is not the case everywhere. For example, in France, we have a much more protective law for authors. So you need a specific clause in your employment agreement to transfer the IP to the employer, but it is not the case in the US or the UK. And the second case where the copyright ownership could change is if the COA was developed in the framework of a work made for hire. So, for example, a creator who is like an expert in their field is hired by a company to create this COA. Then you can be sure that the service agreement or the consulting agreement that this creator will sign will contain transfer of copyright clause, and therefore the product of their work will belong to the sponsor, the person who commissioned the work.
Yes, and as a user, being aware of these aspects is really crucial. Researchers are not always aware of those specificities. We had a case at MAPI with a researcher who, in good faith, was claiming he had the copyright over the questionnaire he developed. He was taking full responsibility of it. It was taken for granted that he has the copyright as per the copyright laws, but we quickly discovered that it was not the case as per the employment agreement with the university. So this could have been tricky not only for him, but also for the users. So this has to be checked by asking the right questions, because indeed, copyright ownership may depend on the university policy related to the copyright, and moreover, the policy may vary from one university to another. So we better check this information. Second case?
Yes, there can also be a shift in the copyright ownership when the instrument is published in peer-reviewed publications, for example, but not only. So when an author publishes about their COAs, they will most likely do so through an article. The COA can be fully published in the article itself, or just extracts of the COA, and it can also be published in an appendix to the article. But in all cases, the author will sign a publishing agreement with the editor, the publisher of the journal. And then there again, there can be a shift of copyright, because if the COA is fully included in the publication, it is likely that the copyright on the COA will then be transferred to the to the publisher. So this is why authors have to be careful to read carefully their publishing agreement. Sometimes in some publishing agreements, you will have a transfer of copyright on the article, but not on the appendixes. So if the COA is published in appendix, then the author may keep the copyright. But this is again like a really place where the author needs to be very careful of what happens to the copyright of their COA.
Yeah, and there are many situations of this type. Very often, the primary objective of a researcher is to share the questionnaire in the publication, to give the opportunity to the readers to actually see the questionnaires, which is always useful for the users. But by doing this, indeed, the copyright may be transferred to the publishers, who will then manage the permission to access, which is fine, actually, but it has to be identified. The tricky thing here is that sometimes the researchers may transfer a right that he may not have the power to transfer, as he may not be the copyright holders, as we have seen previously. So, this becomes even more complicated, and this can lead to disputes. A well-known case is the case of the MRDRS, where there has been a conflict between the author, Professor Montgomery, and the British Journal of Psychiatry. Professor Montgomery unintentionally transferred his right to the journal, and this led to some confusion for the users, as they were provided with contradictory information from the developer and from the journal. So there is a need to determine how this type of situation should be managed and potentially anticipated.
And finally, another situation which we always hear about, and for which there may be some confusion, is related to what we call the public domain instruments, public domain COAs. So first of all, as I explained earlier, the economic rights, the copyright expires, and when it expires, the instrument falls into the public domain. So the copyright duration is the life of the creator plus a minimum of 50 years. It's 70 years even in most developed countries in US and in Europe. And for corporate ownership, the duration would be 95 years from the publication or 120 years from the creation, whichever is shorter. So, of course, we may have a bit of time before an instrument falls into the domain, into the public domain, but there are other situations when an instrument can be right away in the public domain. So it can be the case when IP rights are forfeited or expressly waived, or when a COA has been developed by employees of the US federal government, such as agencies, such as the NIH, for example. So for those works specifically, when we say that a COA falls into the public domain, it means that it can be used, copied, printed, translated, reprinted as desired without any specific conditions, except the condition to cite the source, to respect the right to paternity. But it is actually quite rare, the occurrences where an instrument falls into the public domain. So we have to be very, very careful with this notion.
Yes, and actually many researchers and developers want their COAs to be in the public domain or state they are in the public domain. I'm sure you have already received emails from developers stating that the instrument is in the public domain, right? And that makes sense. Researchers want to make their work useful for the scientific community. They want their work to be used as much as possible without any barrier. However, as we have seen, the questionnaire is likely to be copyrighted. Actually, researchers often make the confusion between public domain and easy access or free access. copyright helps protecting, controlling, and monitoring use and usage, but it does not prevent the COA to be free or easily accessible. This is up to the copyright holders to make them free or not. In addition, the public domain status is actually not ideal for COAs because it complexifies how to access to reliable information. And one can quickly be lost in the multiple evolutions or changes that are possible from the public domain status. So ironically, it is sometimes more difficult and challenging to use a COA that is in the public domain than a COA that is protected by copyright in the end. Now, before going to the next example, again, we would like to get your feedback with a quick question. Curry?
Yes, that's right. We do have one more poll question for the audience here. This time we're asking, following up on all this copyright discussion, in your opinion, who actually owns the copyright in the translation of a COA? And your options are the developer of the COA, the copyright holder of the COA, the translator, or the sponsor. And once again, the question is, in your opinion, who owns the copyright of the translation of a COA? And I'll leave the poll open a little bit longer to allow more of our audience members to get their votes in. Once again, this question is concerning the copyright when it comes to the translation of the COA and who actually owns that copyright. And it looks like the majority of the audience has voted, so I'm going to go ahead and close the poll and share the results. So we do have an interesting split here, but certainly an overwhelming majority of 83% suggesting that the copyright holder of the COA owns the copyright, whereas 12% say the developer of the COA, 4% the translator, and 1% the sponsor. Caroline and Cecile, I'll pass it back to you to discuss these results.
Thank you. Interesting results. Cecile?
Yes, indeed, it's interesting, and again, I feel that we have an informed audience today because you will see that indeed in the COA industry, most of the time the copyright holder of the original COA holds the rights on the translations. So yes, the principle is that the author of a translation, if we take any other work besides COAs, the translator, as the author of the original work, will benefit from the same rights. So they will own the copyright on their translation without prejudice to the rights of the author of the original. So if we take the theory, depending on the situation, COA translation can be owned by the original author of the questionnaire, by the translator, by both, or by the sponsor who finances the translation as a work made for hire, for example. So to avoid any confusion, and again with the aim to preserve the scientific integrity of the COA and the consistency amongst the translation, it has been agreed that the common and best practice in the COA world, with the objective of facilitating access through centralized copyright ownership, is for the original copyright holder to retain copyright in translation. It is actually a condition of the copyright holder to allow translation. It means, like, he will say to a sponsor, I will authorize the translation as long as I keep the copyright on the translation. So the sponsor will pay for the translation, but the translation will belong to the copyright holder, and then he can do whatever he wants with it. So the copyright holder should make sure that they keep the copyright on the translation through contracts, and specifically clauses in the translation agreements that they sign with sponsor. They have to make sure that the contract will specifically state that the copyright on translation will vest in the original copyright holder. And this is contradictory to the usual contract for work made for hire. As I explained earlier, normally the copyright goes to the commissioner of the work. But here, the common practice wants that the copyright stays with the original copyright holder of the COA.
Yeah, thank you, Cecile. Now about electronic versions. Well, electronic versions of the COAs are derivative works of the COAs, and as such will also remain the copyright holder's property. However, for a user, it might not be easy to know where to seek for permission. The fact of having a COA available on an eQua platform or in a digital technology does not mean you can use it without permission from the copyright holder of the COA. So first, eQua providers need permission from the copyright holder to implement or host the COA in their technology. And then the user will have to seek permission from the original copyright holder to use the eQua in the technology. Sometimes the eQua providers will have been granted permission by copyright holders to sublicense the eQua, but it's not always the case. So obviously, the COA copyright holder cannot license the use of the technology. The technology belongs to the eQua provider, but will definitely license the COA for use in the technology. So the two are linked. And there is a need to double check permission to use to make sure you are compliant. eQua providers, if they obtain permission to implement the COA in their technology, will certainly know about the rules and can provide guidance, but being aware of these rules and inquiring about them may avoid potential copyright infringement. Most, if not all, eQua providers, at least in industry trials, are compliant, but this might be less true for platform providers dedicated to healthcare organization and clinical practice, for example. So this has to be checked. Cécile?
Sorry, I was on mute. Apologies. Yeah, so I was just talking to myself here. All these examples Caroline explained shown the importance of performing a due diligence process before starting to use a COA to properly identify the copyright holder and taking into account all these situations. So here at MAPI, based on all the different adventures that we encountered regarding copyright, we put together a unique due diligence process. It's a step-by-step, evidence-based process with a decision tree that we created to help determine ownership. And then based on the results that we get, we can make an informed decision in case of lack of evidence and balance the risks. So this is what our due diligence process looks like. Basically, we will ask questions to the person who claims to be the copyright holder of a COA. And based on the answers, other questions will be asked, and we will come to a result. So, for example, the person who comes to us stating that they are developers, they can be. We have all types of people. So they can be an individual, they can be an academic researcher, they can be a university, they can be a pharma company, any type of developer. And the questions we will ask them, first, we will ask, for example, did you develop the COA with co-developers? Because if you have several people, they could all claim copyright. So from the very beginning, this needs to be discussed. Then we can ask them, were you employed by an organization when you developed the COA? This is about what I said earlier about the employment agreements. Does the organization own the copyright on the COA? For example, if we are approached by a university, we need to make sure that they indeed own the copyright on the COA. Was the COA included in a publication or otherwise made publicly available without any copyright attribution? So for each question that we will get, we will not just take the response without further investigation. We will need to see evidence. We will need documents. We will need to see the employment contract, the publishing agreement with the publisher, the agreement between the co-developers, all of that, ideally, in an ideal world, because unfortunately people don't keep track of everything, but we will need, ideally, we would need to see all of these documents to assess the copyright ownership. And it is also important to perform this due diligence and to keep the evidence, to keep a record of all the questions that we asked and all the investigations we made, so that in the event of a dispute, we can show that we performed our due diligence process. So if you want more information on this due diligence process, you can find them on the white paper that is referenced further in the presentation.
Well, thank you, Cecile. So now we have identified the copyright holder thanks to the due diligence process. The permission is secured and the license can be obtained. So that's a good thing. But the users also need to secure the scientific use of the COAs, which include making sure they are using the right version of the COA, ensuring that the translation they want to use are valid. Same for the eQua versions, making sure they can get access to appropriate material, like the scoring that is needed to score the data and interpret the data, administration guidelines. So we could expect the copyright holders to fulfill this responsibility and thus to provide this information. But it's not always the case. It depends on the copyright holder profiles. And because there are different types of copyright holders and because of all these possible copyright transfers, well, then some copyright holders may not have the scientific knowledge of the COAs. For instance, the publishers, they do license, this is their job, but they may not provide the scientific expertise on the COA. And some others, they may not manage a centralized access to the COAs. For instance, for translations, they are not expert in translation, so they would not manage the translations. So, it gives another complexity for the users to access to reliable information about the questionnaire. So at the end of the day, there may be multiple stakeholders involved to secure the use of the COAs, and their responsibilities may vary depending on their profile. Of course, the easiest situation is when the developer of the scale is the actual copyright holder and then manages the scientific information. But even here, there could be some gaps, for instance, for the translation. So that's why the multiple stakeholders involved in COA must collaborate together. We are better together in order to facilitate access and use. Otherwise, it may considerably complicate the user's journey, as you may know. So to tackle these challenges, the common and best practices in the COA world have been twofold. As said by Cecile, it is for the original copyright owner to retain copyright in all derivative works to protect, monitor, and facilitate access and use of the COAs in global studies. And then to address scientific needs, copyright holders should ensure that the COA communication, COA information, is centralized and accessible to users. I mean, easily accessible to users. If they cannot do it themselves, they can delegate this responsibility to specialized distributors, or in any case, work in collaboration with the different stakeholders that we've seen previously. Centralization of the information is the main objective, as this reduces the multiplication of contacts, it reduces the potential multiple authorizations and paperwork, it reduces the risk of duplication of work, for instance, avoiding to have multiple translation for the same language, which is not recommended in our domain. And finally, it reduces the overall timelines and efforts for implementing a questionnaire in a study. MAPI Research Trust has been using this model for more than 25 years and today manages more than 800 COAs, collaborating with the developers and copyright holders and other stakeholders. We act on their behalf to propose a centralized access to the questionnaires, developing supporting material to make sure the use of the COA is secure. Then from a legal perspective with the licensing process, but also from the scientific perspective. Instruments managed by MAPI Research Trust have all undergone the due diligence process upfront and can be used with confidence. Now, for any other questionnaires, through the database ProColleague, we also help users in their search about COAs by communicating key information that will be useful to perform the due diligence process and thus saving time, because it does take time. You know, identifying copyright holders, as you have seen, may imply numerous contacts, and for some questionnaires that were released years ago, it can be very challenging. In summary, here are a few takeaways for you before using a COA in your project. So I guess I hope you know now that you have to get the permission to use the questionnaire. COA is likely copyrighted, even if you cannot see it. So do your due diligence process. Then from the scientific perspective, make sure you can get access to the final and official version of the COA. Inquire about existing material that goes along with the questionnaires. Inquire about existing translations and make sure they are validated as per good practices. And finally, inquire about specific copyright holders or developers' requirements. Again, ideally, all this information should be provided by the copyright holders. But if not, you have to make sure you can get access to the appropriate stakeholders and specifically to the developers who are really key in the process, as they have the scientific knowledge about their own instruments. Being aware of these situations that we have seen today and anticipating these aspects ahead of time will smooth the whole process and will allow you to secure your trial in the most efficient way. Of course, MAPI researchers can help from end to end in securing this process for you. If you want to get more information, I'd like to invite you to have a look at the recent white papers we released about this topic, but of course we are here to help as well. So thank you very much for your time and for your active listening and for your participation. I think we can now open up to the Q&A session, Corey.
Yes, excellent. Thank you both very much for that insightful presentation. We are now ready to begin the Q&A portion of the event. And as we do so, I invite the audience to continue sending their questions or comments using the questions window chat box. We do already have quite a few questions already here, so I'm going to go ahead and start with the first. This audience member is asking, what would be your recommendations to secure COA copyright ownership for any new COA? What's kind of the pathway look like for that?
Cécile, would you like to take it?
Yes, so for any new COA, I think taking from the start is dating anticipating is what you need to do. So it means, depending on the context of how the COA was developed, you need to decide what you want to do with your COA and how you want it to be, how you want it to be, is life to be. Do you want it to be freely accessible, not freely accessible? How do you want to manage, if you had created it with other authors, for example, if it was developed with co-developers, what do you want to do with this? And everything that you decide should be documented. So as a lawyer, of course, I would encourage you to probably seek some legal advice to avoid mistakes and to make sure that you take the best decision. I would also encourage you to document the creation as much as possible, register the copyright, and also be careful of the publication, what happens when you publish the COA. The copyright notice is also useful, but again, I think anticipation and knowing what you want to do is what is most important.
Yeah, from the start, and try to also anticipate, the future of the questionnaire, what you would like to do, with the translation. You have to decide upfront. And specifically to secure your copyright, try to anticipate all these situations. Yeah.
Okay, excellent. Yeah, and another question here from an audience member. They're asking about how you can frequently see COAs posted on websites, but does this mean that they're in free access? Like, can you produce them from this website, or what's kind of the reality behind that?
Cécile, again, I think, well, I think that's for us an obvious response, but maybe from a legal perspective, maybe Cécile, you want to respond to that question too, because
I'm sorry, I couldn't hear you for a second on the question. Corey, can you?
Sure, yeah, I'll repeat that question for you. The question was asking about how you can frequently see COAs posted on websites. Does this mean they're in free access? Like, can you reproduce them from the website, or is it a little bit more complicated than that?
Yes, of course, and this goes back to what I was saying about the public domain and publicly available. So the fact that you have access very quickly to COA, that you can just type its name on Google, you find it on multiple websites, it doesn't mean that you can freely use it. So you have to be careful again on what you will see. If there's, for example, this copyright notice with a name, this can be also a lead that this questionnaire is copyrighted, and even if you don't see the instructions on how to if a permission is required, you should be careful and make further investigation on this COA. And even if there is no copyright notice, it doesn't mean that it's not copyrighted. As I explained, the copyright notice is not mandatory. So you could even have something without any sort of appropriation or name of author or anything, but still have a work that is protected. So you would need to investigate and to make sure that that you can use or to find the conditions of use.
Yeah, and it might be possible that the questionnaire is posted on a website without proper permission as well. So it's always good to double check. You should always assume that there is the copyright. It is de facto. So it's better to think this way than thinking it's not copyrighted, that you don't need to search for permission. That would be the recommendation. Just double check.
Yeah, very interesting and obviously complicated, and you'll have to take it on do your research there. Another audience member is asking, and also sort of very specific question. What if an author wished for their COA to be used freely, but they then published it in a journal article? Are you still obligated to pay the publisher of the journal in order to use the COA? Probably another very complex situation there. Maybe you can comment on that.
That's an interesting question. I don't know, Cécile, if you want to comment on that, but I would say that it's precisely why we need to anticipate those situations with the publishers, because indeed, if you have published the questionnaire in the publication in its entirety, you will be transferring your rights, and then that will be really the publishers to decide what they are going to do with the questionnaire. If they will request a license, a licensing fee, there are always possibility to discuss. Of course, of a publisher, they are doing. We need the publishers to communicate about the questionnaire. So that's important. We work in close collaboration with publishers, and it may be a good thing that they also license the questionnaire. But then in terms of free access, this is something that you can anticipate. There are Creative Commons license as well that can allow this free access. This is really something that you have to anticipate. But if you don't want at all, if it's too late, that may be some conflict that you will have to resolve as the author. Yeah. Cécile, would you agree on that?
Yeah, no, of course I would agree. And again, as Caroline said, anticipation is really key here, because you would need to be careful on what to do with your COA before publishing it, and read smaller letters in your publishing agreement.
What we say generally, because as I said, in the presentation, of course, it's important to share the questionnaire, but you may not share the whole, the whole questionnaire. You can just share a sample, and then it will change. The transfer might be different in that way. So yeah, there may not be any transfer at all. So it's more giving a description of your COA than really having it published ready to be used. To avoid any confusion.
Yeah, interesting. It's very fascinating. And another question here, I think we've already touched upon this, Cécile, but maybe just as a little refresher, the audience member is asking, does the copyright expire even if the author was employed and then therefore the rights were not, the author's, but it was actually owned by the company?
Yes, indeed. This is what was said earlier. So there's an expiration date on the works that are copyrighted. It depends whether they were created by whether the copyright belongs to a person, where the copyright expires after the death of this person. But if it was owned by a company, then it's longer, and it's you must take the 120 years from the creation, or 95 years from the date of publication, whichever is shorter. But the term is longer for any works that are owned by a company, an organization.
Okay, great. Thank you. Thank you for that refresher on that. Next question here from an audience member, and I think maybe Carolyn, this one is up your alley here. They're asking if can a sponsor that paid for the development of a translation to then reuse it free of charge for additional studies, so that was their purpose, even though the copyright has been transferred to the original COA copyright holder? What happens in that situation?
Well, that varies. That varies depending on the copyright holders. It's really based on the license agreement that will have been signed, between the copyright holder and the sponsor. The condition to translate, and everything is possible. At MAPI Research Trust, if we want to take the example of MAPI Research Trust, we have a model, agreed in collaboration with the copyright holders of a fee that is per study, per translation, and per administration. So it's for commercial studies, So it doesn't, the sponsor who would develop a translation would have to pay a copyright fee again, for the next utilization of the questionnaire. In some situation, for some other copyright holders, it might be different. So that's really a model that is the one that we have at MAPI Research Trust. It may differ from the type of users as well. At MAPI Research Trust, for instance, academic users or not funded academic users, they don't pay anything. So it's really trying to find a balance in the way the copyright holders is going to provide all this information and provide some sort of a follow-up on everything. So it's really kind of the decision of the copyright holders in the end.
Okay, great. Another question here that's interesting, and it seems like a simple question, but there's probably a complicated answer to it. What do you do if you actually can't find the copyright holder? What are the steps involved in that process?
Yeah, so maybe I can start, and Cécile, you can. Well, that's why the due diligence process is so important, because, well, you will have to take a decision. You will have to make a decision. So that's why we call it a risk assessment tool, because that's actually often that it's difficult sometimes to find the copyright holders and to have a robust decision. So in order to make a decision whether or not we should use the questionnaire, generally, I don't think we have any case at MAPI Research Trust where finally we decided not to use the questionnaire, but we have all elements with us to prove that we do our due diligence, and that if at some point we would have someone, that would claim, the copyright or whatsoever, we would be able to prove that we have searched for the information, because sometimes, yeah, it's very difficult to find this information. Cécile, do you want to add anything here?
No, I don't really have anything to add, except that yes, it's you have to put the risks in balance and make a decision. It is unlikely that the copyright holder will find you if you cannot find the copyright holder, especially if you do a real due diligence. But you have to assess the risks, and yes, in some cases you will have to take a risk because you won't have a clear answer. It happens, especially for old COAs that were developed a long time ago, where you don't find records of, you have a deceased author, you can't find the co-developers or all of that. So yes, this can happen.
But we sometimes had the chance to identify and to search by contacting the heirs of the author. Even at MAPI, for the questionnaire that we manage, we now work with the children of the author's deceased, for instance. So it's really making sure that we are searching the information and that we are having only information needed in case there would be a problem. But when we search, we try to find, at the end of the day.
Okay, great. And I think we just have time for one last question here. And again, something that maybe seems like it's simple on paper, but if I've learned anything today, it's that this is all very complex and requires a lot of anticipation and due diligence. This audience member is asking, what steps should you take when you're developing a COA that actually contains items from another COA?
I can start. Well, you should first of all, you should ask permission. You should always ask permission to do something with a questionnaire. Normally, questionnaire, they are protected by copyright precisely. So you are not supposed to modify a questionnaire. You're not. And in addition to that, within our domain, modifying a questionnaire may have an impact, on the validity of the questionnaire. Then, if you want to use specific items for a specific purpose, well, this is open to discussion, but this will require some sort of discussion with the copyright holder and permission. It has to be permitted in the end. Cécile, do you want to add anything?
It can even create a new COA that will be co-owned by the original creator of the first COA and the new one. We have seen this. We have seen some COAs that are the addition of two different COAs, or so yes, everything again, it's all about anticipation. So it means that everything can be discussed and negotiated, but you shouldn't go out and publish and then think that reflect and see that it had been an issue because you didn't ask permission. So always ask first.
Yeah, because there may be conditions associated to the specific situation. So if you want to take some items, modify a questionnaire, well, why not? But there could be conditions behind. So okay, you can do that, but you need to revalidate. Okay, you can do that, but you need to do something. So the copyright holders will actually provide the guidance and the conditions, and users need to respect those conditions, of course. Yeah.
Okay, well, excellent. Thank you both very much for all those answers. Although at this point we have reached the end of our Q&A session. It was a very busy one, obviously, and so to any of our audience members who asked a question that we couldn't attend to because we ran out of time, or if you have any further questions, you can absolutely get in touch with the team at NAPI Research Trust using the contact info currently up on the screen, and they will have a chance to follow up with you after the webinar. Thank you once again, though, for everyone for participating today. I thought it was a great presentation. Don't forget to download the NAPI Research Trust white papers in the handouts module attached to the webinar here, and I have added a link in the chat box where you'll be able to view the recording of this event. You can share this link with your colleagues so that they may register to view it as well. And you will also be receiving a follow-up email from X-Talks that will provide access to today's recordings. And as we wrap things up here, please note that a survey window will appear on your screen. Your participation in the survey is always appreciated. It really does help us improve our webinars. Now, please join me once again in thanking our speakers today, Caroline and Cécile, for such an excellent presentation. We hope you all found this webinar informative, and we wish you all a great rest of your day. Take care, everyone.
Thank you to you, Corey. Thank you, everyone. Bye.